Mr. Leskovich and Mr. Hurley, I see you both in the virtual courtroom. Mr. Leskovich, you may proceed.
Good morning, Your Honors. My name is Stephen Leskovich. I represent the appellant, Mr. Lawrence, who's seated, I guess, to my left, to your right, if I'm looking on the screen correctly. I would like to respectfully ask 5 minutes for rebuttal
Very good.
after Mr. Hurley presents his side of the case here. I'll start with this. I'm going to be asking the court to reverse the conviction for Mr. Lawrence for vehicular homicide, in which he was ultimately sentenced to 111 months in the Florida Department of Corrections. He's out on supersedious bond. And the crutch of our argument is twofold. One, that to impose criminal liability for him backing out of his own driveway is unfair and unjust to do so pursuant to the Union case. And not only that, but when two defendants, in essence, and I'm calling the decedent a defendant in this case, are acting independently and in concert with one another, that each of them alone is sufficient to bring about a prohibited result, which is but for Mr. Lawrence backing out of his driveway, the impact would not have occurred and that a death would not have occurred as well. In order for the state to have proved Mr. Lawrence's guilt beyond a reasonable doubt, they had to prove three certain aspects: that the decedent is in fact dead, or that the victim is in fact dead. The death was caused by the operation of a motor vehicle driven by Stephen Lawrence, and that Mr. Lawrence operated the motor vehicle in a reckless manner likely to cause the death or great bodily harm to another person.
Mr. Leskovich, if you don't mind, I'd like to interrupt you a little bit because I want to focus on your motion in limine for the moment, if you could, because I don't want you to use up your time telling us things that we read in your brief. Okay, so I'd like to focus on that issue because that's of concern to me. And specifically, there was this expert testimony about the blood alcohol level and toxicology results of the victim in this case, and it was the state move to keep it from coming into evidence because they said it's irrelevant to prove the elements that you've just outlined for us. And I believe the case law basically says it pretty much supports that unless it can be shown that that information would be helpful to the jury to determine whether or not the victim was the sole proximate cause of his own death. Is that pretty much the issue from that standpoint? Do you agree with that?
Yes, I would agree with that causation.
Okay.
Yes.
Okay, so, and then you have Dr. Valentine, who was an expert who looked at all this information, saw a blood alcohol level, I think, of 0.107 and blood results showing at least two other controlled substances in the system of the victim at the time of the crash. Is that right?
I believe there was three separate controlled substances.
Three? Okay. All right, but nevertheless, he was under the influence of either alcohol and or controlled substances. And as Dr. Valentine said, he would be in a quote unquote euphoric state that would not permit him to operate a vehicle in a safe manner. Is that accurate? Do you agree with that?
I do agree with that. Yes,
okay. So here's my question. Sole proximate cause, that's pretty tough. And to me, that's the issue I'm trying to drill down on. If this evidence would have come in, would the jury been able to find that the victim was the sole proximate cause of his own death? Now, it's proximate cause, probably sole proximate cause is a little harder for me because there is this backing out, this very unfortunate backing out into a neighborhood, coupled with all of this evidence. If it would have come in, certainly a jury could find that there was the victim had contributed to the proximate cause of his own death, but it's the sole proximate cause of his own death that I'm struggling with. Can you help me with that?
Yes, sir. And I'll use the Velasquez case as kind of a way to help explain this as well. In Velasquez, we have individuals who are drag racing, and then at the end of the drag race, the decedent, he wasn't dead then, but the decedent ended up turning around, racing all the way back towards the finish line. And in that case, the District Court of Appeals said it would be unjust and unfair to hold the defendant liable because of the actions of the decedent. It's kind of a similar situation here. What Mr. Lawrence had did was he backed out of his driveway, and albeit most people, as we would reasonably do, turn their vehicle as they're driving in the direction in which they're going to go. Mr. Lawrence, according to the evidence, backed straight up in his 20-foot long Suburban. When we have the victim of this case who is under the influence to the extent that his normal faculties are impaired, along with all the other numerous traffic violations that he's committing, it was the impact.
Mr. Leskovich, didn't
Yes,
the
Judge.
trial judge specifically address in the order on the motion in limine that the victim wouldn't have had time to react regardless of his impairment, given the timing of the backing out? And my other question for you in that regard is the expert, Mr. Valentine, he agreed that the actual cause of the victim's death was the impact with the vehicle, right?
That is correct. That's what Dr. Valentine said, yes.
And Valentine didn't watch the video, but the trial judge in the order made a finding that, if I'm not mistaken, the timing, and they were able to reconstruct this, of the approach of the decedent on his motorcycle was such that his impairment had little, if anything, to do with his ability to avoid the accident. Do you disagree with that?
I do not know.
I interrupted you. I have to take your answer.
Okay. The being that he's backing out of his vehicle, I guess I'm going to try to answer both of your questions or your statements together. Being that he's backing out of a vehicle, the victim was traveling in excess of 20 miles an hour over the speed limit in a residentially marked 30-mile-per-hour zone.
And the speed limit violation, when the jury heard about that.
Excuse me?
The jury heard about at what speed the victim was traveling. The only thing that was excluded was the toxicology evidence, correct?
The jury was partially correct. Yes. The jury heard that he was traveling 50 miles an hour. The jury was not allowed to hear that the victim contributed or caused his own death.
And to the point that you analogized the Velasquez drag racing case, this wasn't a drag race. And I just would like to draw your attention to a hypothetical in the Velasquez case where they talk about, and I'm looking under the head note, the discussion under head note 5, the hypothetical where if the deceased had collided with an oncoming motorist who happened to be in the vicinity, lawfully using the subject road, resulting in that motorist's death, the oncoming motorist could in no way be said to be responsible for his own death. And isn't that more like the situation that we have?
I don't think so, no. And I'm going to take the roles a little bit different. Had the victim survived this incident, I would presume he would have been charged with driving under the influence. So we have two potential criminal acts going on here, according to the state. One would be a DUI, one would be a reckless driving. The difference is that when you have the reckless driving, backing out of a driveway, is it reasonably foreseeable that an individual driving down a roadway in a residential neighborhood in excessive speed?
Analysis.
Excuse me?
The criminal point here, and Judge Morris spoke to it at the beginning, is unless it can be shown that the victim's conduct was the sole proximate cause, it's not a reasonable foreseeability analysis, is it?
It's not a reasonably foreseeable analysis, no. It's a sole proximate cause, or is it unfair or unjust? And that's where we believe that the court didn't properly look at the Union case when they did their order on the motion in limine.
One of the difficulties I'm having with the position that you're taking is it seems to minimize what the state's contention was in this case, which is that your client basically laid in wait for the victim to again resume his drive. Apparently he had gone up and down the street, or someone had gone up and down the street a couple of times. If the state's theory was that your client laid in wait and then pulled out intentionally to block him, perhaps not to result in the accident, but intentionally to interfere with the passage of the victim, how does the victim's drug use and alcohol use come into play without confusing the jury? Because that seems to be what the trial court focused on, is that balancing test of one, relevancy, two, what will the impact be on the jury? And looking at the sole proximate cause analysis, it seems like the judge concluded that his drug use had the potential of not just inflaming the jury, but misleading the jury. So why is that analysis not correct?
When I look at the JAC case, where the defendant in that case was involved in a drag race, and the passenger of the vehicle grabbed the steering wheel instead of grabbing the gear shift. It's kind of the same way, where if the victim of this case
wait, let me interrupt on that. I mean, that doesn't seem to be, to me, to be at all analogous. You have a passenger doing something that I don't think any reasonable person would foresee. Whereas the state's theory in this case is if your client laid in wait, which is what they contended, then it was reasonably foreseeable that if he pulled out and blocked the roadway after waiting for the victim to approach on the roadway, that the resulting accident was foreseeable.
I would partially agree with that. Yes, sir. That's what their theory was during the trial, is that Mr. Lawrence laid in wait when he looked to the left, looked to the right, looked to the left, waited 6 seconds.
Hang on a second, because I thought your witness said that as best he could tell from the film, the video, it appeared your client was looking to the north, which is the direction from which the victim was anticipated to be coming, wasn't it?
That's correct. Yeah, and that's when I say he's looking to the left. He's looking to the north, where the victim would be traveling southbound.
You said looking left, looking right, looking left. That was there testimony by the expert to that effect?
Not by the defense accident reconstructionist, and looking at the video itself, there was testimony that he was looking to the left. Looking to the north, looking to the left, looking to the north, reversed his vehicle back.
When the trial judge ruled on the motion in limine and entered the order that he appealed, the trial judge expressed concern that Mr. Valentine hadn't seen the video. And the implication, and you can correct me if I'm wrong about this, was that the trial judge had seen at least some of the video in this case when he was performing his balancing test. Am I right about that?
That's correct, yes.
And so now we're looking at this through the lens of an abuse of discretion on that balancing test. And I'm struggling with the notion that no reasonable person in the trial judge's position could reach the conclusion that he did with the information that he had at the time he made the ruling. So help me out with that.
All right, and in my brief, I had argued two components: that the trial judge properly cited what the union case said, that unless the decedent's conduct is the sole proximate cause, it becomes irrelevant and it's not going to come in. The impact between the motorcycle and the Suburban caused the death of the victim. That's undeniable. But it's my contention as well that the trial court did not look at the union case in terms of, is it unfair or unjust to hold Mr. Lawrence liable for backing out of his vehicle when we have this motorcycle doing all these traffic infractions, as well as, in essence, a DUI as well. But looking at the balancing test itself, we have two independent intervening acts going on. So if I look at, is or when I look at the relevant testimony itself, is it relevant? Absolutely, it's relevant to the defense's case in chief. Is it irrelevant to the state's case? Absolutely. But when we look at then, does the probative value outweigh the danger of unfair prejudice? That's where we believe the judge made the mistake. Looking at that is because we have two independent intervening acts going on. The sole reason why the victim is in fact now the decedent is because of the impact. Had the decedent been traveling the speed limit, had he not been impaired, had he not been violating
to me, that all sounds highly relevant in the context of the comparative negligence defense. But what I think you're saying fundamentally is where you point the finger at the trial judge for using his discretion, is the fair and just argument that you've made. And the statutory elements of this crime that Mr. Lawrence was charged with are, kill a human being, we have a dead victim. Operating a motor vehicle, we have that. In a reckless manner, likely to cause death or great bodily harm to another. And Mr. Lawrence, for whatever reason, backed his vehicle straight out of his driveway with this motorcycle right on top of him. And as a result of the collision between the motorcycle and the car, the victim is now dead. So I'm having trouble with the notion that I can read a fair and just component into that last element. And now my expectation is that Mr. Lawrence did not intend to kill the victim, but he did there's a good argument to be made that the operation of the vehicle was done in a reckless manner that was likely to cause, if not death, great bodily harm, and that is what happened.
I respectfully disagree with you. When we look at the third prong of the jury instruction of what the state has to prove as well, that he operated a motor vehicle in a reckless manner. Well, what's reckless? In a wanton and willful, and wanton disregard. Willful is the intentional, purposeful, and willfully doing so. And then you have the wanton component where you have a disregard for the consciousness that death or great bodily injury is going to occur. So is backing, if Mr. Lawrence had been cited for improper backing, I could potentially understand that because it's a due care analysis with it. He lacked due care in backing out of his driveway. Does it rise to the level of criminal where it's actually reckless driving, backing out of your driveway?
Well, it sounds like the state's position that he laid in wait almost makes it look like their position was what he did was intentional, that he was waiting for this guy for whatever reason, and he deliberately was trying to block him. That sounds like that's what the state's case was, and it sounds like that's what the jury was persuaded. Am I not right about that?
I don't disagree that that's what the state's case was.
Okay. And so the jury must have found there was evidence to support this lay in wait allegation, and therefore what he did was intentional, not negligent, not careless, probably not even reckless. It sounds like their position was what he did was intentional. Is that right?
That's what the state's case was, correct.
Okay.
Mr. Leskowitz, just to let you know, because of the number of questions, I let the clock run a bit. If you want to reserve your 5 minutes, now's the time to go ahead and do so.
Okay, thank you. Then I'll go ahead and then reserve some time now.
Very good. Mr. Hurley? Mr. Hurley, don't forget to unmute your microphone. There you go.
May it please the court, Jonathan Hurley representing the appellee, the state of Florida. The issue is whether or not the trial court abused its discretion when granting the state's motion in limine. I think importantly, from a factual standpoint, whether or not a reasonable juror could find as the trial court found, I think keep in mind the trial court had the video, watched the video in this particular case prior to the motion. So we also have the trial court. You have to say that no reasonable juror watching the video as the trial court did could find factually the way the trial court found. That's from a factual standpoint and whether or not the court abuses discretion. State would argue that from a factual standpoint, the trial court, there was competent, sufficient evidence to support the trial court's finding that the defendant's motor vehicle caused this accident, caused the death of the decedent. The second issue is whether or not the court applied the facts to the law correctly. And in this case, as it's been discussed numerously, based on union, the decedent's actions had to have been the sole proximate cause of the accident. In this case, it's clear. Even the defense's expert at the motion hearing could not say that the victim was 100% caused the accident. So again, factually, the record supports the trial court's finding. With regards to the unjustness based on, let's say, the Hodges or the Velasquez case, the issue what we bear down on is, could the conduct of the defendant, again, looking at the video shows the defendant backing straight out and blocking the entire roadway, not just one side of the roadway, the complete roadway, so that there was no place for the victim to avoid the collision. Backing out the way that the defendant did seconds before the victim approached. Could that conduct, is that foreseeable that could result in great bodily harm or property damage if you just, without looking at the motion hearing, and the video shows that the defendant is only looking to the north in the direction of the decedent. If you back straight out of your driveway without looking both ways and blocking the entire roadway, is it foreseeable that could cause great bodily harm or property damage? The state would argue that's foreseeable. So from a standpoint of the unjustness, I don't think it was from that union, from the second part, which
Well, Mr. Hurley, on the unfair, unjust sort of analysis, the conduct that you've just described may or may not be reasonable, given the logistical circumstances of the driveway and the road and all of those things. But isn't the key point here that the experts testified that the defendant's vehicle came out with in proximity to the victim with such a short time space that whether he was under the influence or not, no one could have stopped in time? Isn't that pretty much what the testimony we have?
Not only the testimony, we have the video. I think if any one of us looked at that video and saw the amount of reaction time from when the defendant's vehicle pulls straight out and blocks the entire roadway to when this decedent's motorcycle was coming across, whether or not the decedent was euphoric on drugs or alcohol or not, based on looking at the video, I don't think you could say that there was any, it was relevant in any way.
So the state's theory in this case that this was really almost an intentional act, is that correct?
The state's theory, correct, that the defendant knowingly blocked the roadway, complete roadway, seconds before the victim approached.
Okay, so we have a video of that, and we have the logistics of how he backed out. What other evidence is there to show this sort of intentional act on his part? In other words, you say he intentionally backed out, or he intentionally was trying to block this particular victim?
The video shows, well, we have a number of things. Now, again, this was not an issue of JOA, so we're not addressing the sufficiency of the evidence. We're simply addressing the motion to eliminate. But from, and again, the jury had a, it was a jury's decision whether or not they found as the state theorized. The other evidence, if you're talking about the sufficiency, was there was a 911 call that was presented where the defendant talks about, it seems to, you can infer from the 911 call that the defendant did in fact observe the decedent coming his way. There was also evidence of, as Judge Silverman talked about prior to this, that this motorcycle was going up and down the roadway. But that really goes to the third issue, and that was whether or not the defendant, whether or not the manner of his driving was reckless. You also had evidence of the volume of the noise, the RPMs from this motorcycle coming as well. So you had that evidence coming in.
Mr. Hurley?
Yes.
The jury actually watched a simulation, didn't it, of this motorcycle?
Well, the surveillance video, correct. And mine also, from even assuming, as taking the appellant's side, mind you, the issue was at this trial really had to do with the reckless manner, whether or not the state's theory was proven, the knowingly. The defense was able to present a complete defense, in that they presented a doctor dealing with the defendant's hearing abilities, because that goes to rebut the state's theory that the defendant would have heard this motorcycle coming. They were able to present their own traffic reconstruction expert who testified that the visibility was obscured.
Mr. Hurley, the reason I asked you about the simulation exercise and the sheriff's deputy performed that was that I believe the state offered that evidence to establish that Mr. Lawrence unquestionably could hear the motorcycle at the time that he backed out of the driveway. And isn't that what the point of that evidence was?
Well, I mean, I think the evidence was to show not only the causation, that in fact the defendant's vehicle caused the death, the blunt force trauma to the victim, but more importantly, it was to show the knowingly, the state's theory of that the defendant laid in wait. I think when you look at that, you see that the defendant is looking to the north seconds prior to this, and then the manner of this wasn't just kind of a gradual, straight on back, timing wise, to time it out that the motorcycle was coming this way. So it was really to show, the state had to show that it was, again, it was not just negligent, that it was in fact, the recklessness was the knowingly blocking the roadway, that as the decedent is approaching, that's the conduct that the state was demonstrating with the video. If there are no further questions, the state would ask you to affirm the conviction. Thank you.
Mr. Hurley, Mr. Leskovich.
Just briefly, Your Honors, and thank you for the rebuttal time. I wanted to address a question that Justice Morris asked counsel here, that the decedent was 300 feet away and traveled 300 feet in 4.07 seconds. When you're looking to the north, there was a white SUV obstructing the view of Mr. Lawrence. It wasn't until approximately 1.1 seconds when Mr. Lawrence was out of his driveway before impact when there was the possibility of visually seeing the motorcycle. And to directly answer Judge Morris's question, the accident was in essence inevitable. The reason why it was inevitable was that the decedent was 158 feet away and traveled that feet in 1.1 seconds before impact. Had the decedent, let's just say hypothetically, been traveling the posted speed limit, the defense reconstructionist was able to say there would have been proper time to stop the motorcycle. But that then goes into that's only assuming that the decedent wasn't impaired to the extent that his normal faculties were impaired. It also goes into a fact that he was riding a motorcycle that had brakes. It was also taking into effect that the decedent had a motorcycle that had proper exhaust systems and a proper carburetor on it. So when you take all those other factors into account,
those factors, Mr. Leskovich, those factors came into the jury's consideration. The only thing that the jury didn't have is whether he was intoxicated or on drugs, correct?
The toxicology was not permitted to come in, and the trial judge did not permit the argument that the decedent's actions contributed or caused his own death. That was precluded as well.
The jury heard a fair amount of evidence concerning the speed limit, the condition of the motorcycle with regard to brakes and everything but, and just in terms of the evidence, not what argument was permitted. The jury got that evidence, didn't they?
The jury received the majority of that evidence, correct. They did not receive because of this evidence that caused or was the sole causation of the death. And then also addressing there was a plethora of evidence that came in, but going back to as well with what Mr. Hurley had indicated, the trial judge may be in the best posture to make a ruling. And I don't disagree with that because that's what the case law and precedent says. However, the case law also says that whether he's the sole proximate cause or it's unreasonable, or that whether it's unfair or unjust. So when Mr. Hurley indicates that the trial judge is there to apply the facts to the law, union has two components to it, not just one component, which is the sole proximate cause. So Mr. Lawrence was precluded from arguing causation, and he was precluded from saying it was unjust as well. So if there's no further questions,